Good afternoon. This is Bill Bronchick, and welcome to Wednesday webinars, where we talk about, did I say Wednesday webinars? It's Webinar Wednesdays. I'm sorry. Where on every Wednesday at noon Mountain Standard Time, which is right now, we're going to be talking about real estate, legal and business issues affecting your real estate business. Today, I'd like to talk about 8 legal pitfalls for landlords. This will apply to you if you're a landlord, if you're thinking about becoming one, if you got single family, multifamily, Airbnb, condos, apartments. Really doesn't matter. All of these issues are going to apply to you, and many of them even in a commercial setting if you're a commercial landlord. So we'll go about 35 minutes on my presentation, and then we'll take some Q&A at the end. So be prepared with your questions. You can type them in the chat there, and I'll be happy to answer them live when we're done. If you are watching this as a replay, you can always email me. My email is bill@bronchick.com, bill@bronchick.com. So let's get started. Legal pitfall number 1 as a landlord, personal injury. Now, this is the obvious one that people think about, someone getting injured on their property, becoming liable, and so on and so forth. Understanding that property liability does not come automatic, meaning if someone is injured on a property you own, you're not automatically liable. Someone's got to prove that you did something wrong, that you were essentially negligent in most cases, meaning you failed to do something or you did something that wasn't reasonable and as a result caused an injury that was foreseeable. Okay, that's basically the definition of negligence. Personal injury is probably one of the most common things that will happen to you as a landlord in terms of liability. You got to be concerned about certain things like latent defects. What is a latent defect? A latent defect is a defect in the property that is latent. That means not easily discoverable. So, for example, if there are issues with plumbing in the walls that you're aware of, leaks and things that cause mold, and you don't disclose that to a tenant, and that tenant as a result gets sick, you could be held liable for that latent defect by not disclosing that, because how would they know other than ripping open the wall, which of course you're not going to let them do on a showing. I'll give you another example. I had an apartment that was above a garage of a house that I lived in. It was a separate apartment that had a separate spiral metal staircase that with a separate entrance you go in. Now, when I was renting it in the summertime, I would disclose a latent defect, which was in the wintertime, that metal stairway would get icy and hazardous and dangerous. And I made sure that I disclosed that in writing and had a tenant acknowledge that risk and initial that particular provision of the disclosures in the lease. That's a latent defect. It's not obvious in the summertime that there is a hazard in the winter. If you've got a property that has bears on bear season and you're renting it at a time where there's no bears present, that's something you should probably disclose. Those are all latent defects. Number 2, guest and trespasser liability. Now, most people are worried about, well, my tenant might get injured, but they're forgetting that a guest of a tenant is just as likely to get injured, and you would be just as liable for the injury to a guest. Are you also liable to a trespasser, someone who trespasses across the property or breaks into the property? We've all heard of the sort of old wives' tales of someone breaking into a house and then getting injured as a result on the window and then suing the landlord. Or in law school, they used to talk about landlords or property owners who would set up traps. So when someone broke in, a trap was set which would injure severely the intruder. No, you can't do that, by the way. That's you could get sued for that because you're purposely trying to injure someone, and if you have a reasonable suspicion that someone might break in, then you don't have the same duty to them as you owe to a tenant or a guest, but you do have some liability to make sure that things that are not easily discoverable, like latent defects, are taken care of. For example, let's say that you had a hole that you dug in your yard for whatever reason. Maybe you were going to do a pool and then you filled it in. Or you did some work on a sewer line or something like that. And there was some sort of covering over that hole. Maybe you left a covering for future access that was made of plywood, and that plywood started to rot. If a trespasser stepped on that and got injured, would you be liable? And the answer is probably you would, because you can anticipate trespasses, particularly if you have a property that people routinely trespass on. They cut through to get to something, whether it be a highway or a community pool or going through a forest, especially if you have a big property. So you do owe some liability to trespassers as well. Attractive nuisances. These are things that tend to attract children, and children are likely to get injured on it. And of course, the most common one is a pool. A pool is an attractive nuisance. You're required, usually by local and code enforcement, to keep a certain height and quality of fence that's locked around a pool for the safety of neighbors. Now, if it's someone that you invited over, that's one thing, but what about trespassers? Yes, attractive nuisances can have liability consequences to trespassers, because if you have neighbors have kids and you have a pool with no fence, it's reasonable to assume that the kids might trespass on your property and use your pool and drown. Or maybe a kid just doesn't know any better. A 3-year-old bounces his ball in the yard and it rolls over into your pool, and the kid's going to go get it and falls in and drowns. That's something it's foreseeable. So you would be liable for that. Trampolines, another thing I wouldn't allow a tenant to have, a pool or a trampoline. Anything that would tend to attract children who don't know any better is an attractive nuisance. Having tenants do work, this can often be a hazard. Now, a lot of people will have tenants that call up and say, hey, my screen door is broken, or there is no screen door. Can I install one? And then you pay for it, Mr. Landlord, and I'll do the work. That's probably okay, because I can't see someone really getting seriously injured installing a screen door. But I wouldn't have them do electrical work or plumbing work or something on the roof where they could fall off, unless they are qualified to do that work. Maybe they're licensed in that profession, and still get something in writing that they assume the responsibility and they assume the risk of that as well. But be careful of tenants doing the work. You could have liability for that. And then failing to report incidences is a real big pitfall. Now, a lot of these things that I mentioned may be covered by homeowners insurance, or if it's a rental property, liability insurance. And I think you should carry lots of insurance for this reason. Most cases are settled out of court, and therefore the big expense is the legal fees. An insurance policy covers your lawyer. So if you rack up 50 G's in legal fees and then settle it for 50, not only is the insurance company that could cover the 50, but they're going to cover the 50 for the lawyer fee. And that's good. Even if it's a completely bunk case and they're just suing for nuisance value, and the settlement is $10,000, if it costs you 15 attorney's fees, you lose even though you kind of win. So having insurance is a good thing to have, but insurance requires that you report any incident within a reasonable time period that might later lead to liability for you that's covered under the policy. And most people don't do this because either they don't take it seriously enough, so they don't bother to report it, or B, they think that nothing's going to happen legal wise because, it's a friend's neighbor or a neighbor's friend or whatever. They were on the trampoline and you turned your back for a minute and the kid broke his leg, but hey, it's no big deal. These things happen. 6 years later, you get sued. You know, it's a possibility when you're not friends anymore. And the problem with that is, more than likely, when you renewed your policy that year, it asked, did anything happen, any incidents that might lead to a claim later that we need to know about? And most people will say no, because they're afraid their policy rate will go up or they'll get canceled. So they brush it under the rug and they figure, well, it's been 9 months, nothing's happened, so I'll say no. And then 3 or 4 or 5, 6 years later, they get sued and the insurance company says, sorry, we don't cover that claim because you didn't timely report the incident. Happens all the time. Make sure if anything happens, report. I know your rates will go up. I know there's a possibility they could drop you, but that's better than getting sued years later and having even no coverage and nothing for attorney, even if it's a completely bunk claim. Legal pitfall number 2, independent contractors. This is a big issue that comes up with landlords. Landlords don't like to have employees, they hire independent contractors. If a contractor is paid more than $600 a year and is not a corporation, and is an LLC a corporation? It is not. An LLC, especially if it's treated as a single member or partnership, is not a corporate entity under this reporting requirement. So even though the handyman you paid is an LLC, you must get a W-9 from them and they have to show to you their tax ID number and their filing status so you can send them a 1099. Okay? If you don't do that, the IRS could fine you for non-filing of those 1099s each year. So don't assume because someone's an LLC, you don't have to do a 1099 unless they're a corporation or an LLC electing to be taxed as a corporation. And the only way you know this is ask them to provide a Form W-9. If they are an employee, then you must W-2 them, withhold, and carry workers' comp insurance. So on the one hand, you don't want to deal with that nightmare, but you'd rather call them an independent contractor. The challenge is the IRS, as well as the more likely your state Department of Labor, if they audit you, and usually what happens is the person you paid didn't pay their taxes, so they follow the trail back to you, and then they audit your books going back 3 years and see every person you wrote a check for that is unincorporated for the last 3 years and ask, who was this person? What did they do for you? Show me paperwork. Guess how I know that? 3 times been audited on that. 3 times. 1 each time, but 3 times. So this is the test factor they're going to look at, and the State Department of Labor is going to want to call them an employee so they can get you to pay the taxes that this person didn't pay. So first, whose hours did this person work, yours or his? Did you hire a contractor to do a job and say, be here from 9 to 5? Or did you say you got 2 weeks to get it done? Did you supervise? Or did you say, the job is yours, I'll stop by once in a while, see how things are coming? Whose tools did they use, yours or theirs? That's important. Independent contractors have their own tools. This is a key one. Did you pay them by the job or did you pay them by the hour? A lot of people do this. They independent contractor people on a part-time basis by the hour instead of calling them a part-time employee and then putting them on the payroll. Does he do work for other people or she do work for other people other than you? Is there an independent contractor agreement? That would really help. It's not the end all, but it really helps to bolster your argument that you had an independent contractor agreement, and that independent contractor agreement would say he or she uses their own tools, is not supervised by you, is not paid by the hour, paid by the job, and works their own hours. Okay? And again, who's watching? A lot of people are worried about the IRS on this, but the State Department of Labor is really, really the troublesome one, and they're going to come up, and give you basically a financial enema if they get word that you are trying to skirt the system by paying everybody who works for you as an independent contractor. So be very careful of this. Legal pitfall number 3. Discrimination and the American with Disabilities Act. I kind of lumped these two together because they kind of go together in terms of screening potential tenants. Now, discrimination, this is a weird issue. Number of people per bedroom. You can't discriminate based on familial status. That means whether they're married, unmarried, have kids or no kids, or how many kids they have. But there might be a local code that says only 2 adults per bedroom or only 3 adults per bedroom. And you're renting a 3-bedroom house and an applicant has 11 kids in a 3-bedroom house. Is that okay to put 2 adults in 1 bedroom and 11 kids in the other 2 bedrooms? Probably going to violate local code, but you're discriminating based on the size of the family. When in doubt, follow the federal law. Federal is supreme over state or local. Some states prohibit arbitrary discrimination, and this one really bothers me, California in particular. It is illegal to discriminate against protected classes. And those are the obvious ones are race and sex and national origin and familial status, whether they have kids and how many kids, et cetera, et cetera, et cetera. Those are the obvious ones. But being a jerk is not a protected class. So if you meet someone and go, this person is a real jerk, I just don't want to deal with them as a tenant, regardless of the fact that they belong to any one of those protected classes. In some states, that's considered arbitrary discrimination. Just arbitrary. You just made up some rule like, they drive a Ford Camaro and you don't like Ford Camaros. So if you do bounce someone on an arbitrary basis because they're just a jerk, and a jerk is not a protected class, make sure that you have some sort of internal checklist or screening system that you use when you review their application that is subjective, but you could show to the world or anyone who's looking is objective. Let me give you an example. A question like, how was their demeanor when they showed up for the showing? That's subjective to you, but you could rate it on a scale of 1 to 10 and have a point system you add up based on that and other factors as whether or not they get the apartment, whether or not they're approved. So have some sort of system and follow it. Now, the American with Disability Act requires you to make, as a landlord, reasonable accommodations. Now, most of this doesn't apply to single-family homes, but reasonable accommodations you do have to make. So, for example, if someone wants to make a temporary ramp at their expense in front of the house, you really can't say no. I mean, you're probably not a nice person if you say no, but if it's not permanent, who cares? But if they want you to make permanent expensive modifications to the house, or they want to make permanent modifications to the house that might affect the value of the house in the future or the ability to rent it to other people, you can say no. You can say no. Now, apartment buildings have specific things they're required to have to be ADA compliant, whereas single-family homes do not. But you're only required to make reasonable accommodations, not unreasonable accommodations. Pitfall number 4, environmental liabilities. This could be a real hazard, no pun intended. Actually, the pun was intended. Mold. You got to deal with mold. And whenever you have a water leak inside the walls, whenever you have a hot water heater that explodes and floods all over the place, you always got to make sure that even if you got the remediation service to come in immediately, open up the walls, dry everything out. You really should go the extra mile to make sure that there is no mold and have it inspected. Lead paint, that's an issue. Properties built before 1979, you must give a pamphlet and you must give a disclosure of, it's a standard form. You can go to epa.gov. It basically says your knowledge of any lead in the property and so on and so forth, and any reports in your possession that you know of. And of course, the answer is always no. But lead can be a liability issue, especially if you disturb things like changing out windows, changing out window sills, changing out drywall where there was previously lead paint, especially in older buildings and older houses. Could be some major liability issues, so make sure you do everything by the book if you do that. Radon is a new one. Radon is not that hard to mitigate, and there's specious research on whether that really hurts you or how much really radon really hurts you. But if you do, when you buy the house, you should do an inspection for radon and make sure if it's prevalent in the area, you should check for it. Asbestos. A lot of old houses have asbestos, and typically things like asbestos tile or asbestos in the attic. As long as you don't disturb it, you're generally okay. But if you do disturb it, you must do it by the book, which usually requires a certified, compliant asbestos removal company that does it with a permit and does it by the book. If you don't, you can get yourself in a lot of trouble and potential liability. Now, here's a new one: secondhand smoke. So you could say no smoking, and then a neighbor in the apartment building is smoking and it's coming through the unit and bothering another tenant who is asthmatic. Would you have liability for that if you allowed or permitted or did nothing about other tenants smoking in a non-smoking building? And the answer is absolutely. A previous meth lab. I had one of these. I had a property that had a meth lab. Now, the rule's different from state to state, so you need to check this. But in my state, if you remediate it by the book, which means you have to use an OSHA-certified contractor, you have to strip everything down to the studs, you have to, put an all-new drywall, you really got to gut the house. And if you do it by the book, then you don't have to disclose it. Now, as a practical matter, do you really want the tenant to hear from the neighbor, "Oh, you moved into the meth lab house"? It's going to create some bad blood between you and your tenant. So you may want to disclose that there was a meth lab and it was remediated, and a few parents with kids might say no. But most people, if you show them the paperwork that it was remediated and it probably looks beautiful because you gutted the place, then it's not that big of a deal. Pitfall number 5, animals and pets. Notice how animals and pets are not necessarily in the same category. So let's look at what you can exclude. You can exclude or charge more for service animals, and you shouldn't anyway. However, what exactly is a service animal? Are we talking about someone who's blind and needs a dog, someone who has post-traumatic stress disorder and needs a dog for that and who's trained for that? That's fine. What about someone who's just, I need my little corgi, I need my little chihuahua because then I get anxiety if I don't. That's become kind of like a gray area, and it's okay for you to ask if the dog is a service animal or a support animal. Okay? Now, in terms of liability, dogs have what is called the one bite rule. So even if you have a service animal, if that service animal bites somebody, you're on notice that the dog has a propensity for violence. And if they bite someone a second time, you're now liable. So you're not liable if you let a service animal in and it bites someone, because how would you know? I mean, you have to let the dog in anyway. Not likely that's going to happen anyway. A service animal is not going to be aggressive. But if you let someone in with a dog and then they turn around and bite someone, and you have no history of knowing about this animal biting someone, then you're not necessarily on the hook for liability. But once they do bite someone, then you have to tell the tenant to get rid of the dog, and you should have that in your lease. Unless it's a service animal, then we're gonna have to make accommodations. Exotic animals is a no-bite rule. So if there's a snake, a boa constrictor, or some weird kind of exotic animal, there's the no-bite rule. I mean, once they bite somebody, you're liable no matter what. And then there's illegal animals. So in the city in which I have a lot of rental properties, there's a ban on pit bulls. Now, whether you're a pit bull fan and tell me, oh, my pit bull's the most wonderful dog in the world, that's all great. But if the city says it's illegal to have a pit bull, you can't allow someone to have a pit bull. Now, what if their service animal's a pit bull? Federal law allows it, and then local code says no. Oh, boy, that's a really tough one. I don't know the answer to that one. You may have to go to the city and say, hey, I know you ban it, but this person has a service animal, and federal laws under the American with Disabilities Act says I have to allow it. Probably not going to happen, not too many service pit bulls, but statistically, pit bulls are the most aggressive in terms of reported dog bites. So I don't care whether you love your pit bull. Generally, as a principle, I just probably wouldn't allow them. Legal pitfall number 6, pests. And that's pests other than the tenants. Now, my raw attempt at humor here, not very good. Pest control. Roaches. Now, roaches are a problem because roaches, if you have a multi-unit, roaches scatter and then they go to the next apartment and then you spray and they come back. So you have to bomb the whole building, and at your expense, you're going to have to pay for people to stay somewhere maybe for a night while it's being bombed if it takes more than a day for the chemicals to subside. Bed bugs. This is a really tough one. Okay, so my rule is if the bed bug problem occurred within the first 6 months of them moving in, we'll take care of it. But if it's after that, you know darn well they brought the bed bug in by getting a used mattress, used piece of furniture, or something like that. Bed bugs don't just hide for 6 months. You know, it's going to be a problem. Now, Colorado, for example, amended their habitability law, because landlords have what's called a duty to make a property habitable, regardless of what the lease says. And they've added that bed bugs are habitability issues. So they're making landlords be responsible for this, even though the tenant may be at fault, and it's gonna present some problems. Mice and rats, same thing. Those could be habitability issues. Wild animals, well, there's not much you can do about that. Raccoons, cougars, bobcats, bears in the garbage. All you got to do is disclose, because you can't control wild animals in the outside that are outside your unit. The key is disclosure there. Pitfall number 7, moving right along, a bad lease. It's very important that you not only have good application, which is probably another one that should be on this list but is not. You have to have a good lease. And here are some lease contract clauses that should be in your lease, among many others. Late fees. Now, late fees, a lot of landlords will charge maybe 5 or 10% of the payment. And that may be more than state law allows. So make sure you check your state law. I know Colorado's got a bill that proposes limiting it to 3%, which I think is ridiculous. And they're also going to try to say you can't charge a late fee until the 15th of the month, which is even more ridiculous because we have mortgages to pay by the 15th. But make sure you know what your state law is on this. If there is no regulation, I would recommend something like 5 or 10% of the monthly payment plus a per diem. So if they don't pay by the 5th, they pay 5% of the monthly rent, plus maybe $10 a day or $5 a day, depending on what the monthly rent is. That way, it's an incentive for them to pay earlier than later, even if it's late. Because if you only hit them one late fee, like mortgage companies do, what's the difference if they pay on the 6th or the 18th or the 25th? It's only one late fee, right? So you should have a per diem. Bounce checks. A lot of landlords get really mad and charge a hefty bounce check fee. And this is regulated by state law. You got to check what you can actually ding them for. In my state of Colorado, you can't ding them for what other than what your bank charges. So if your bank charges $20, you can't charge $100 for the inconvenience. Habitability. Can you pass that on to a tenant? In most states, the answer is no. In some states, you can if there is separate consideration for this duty. So a landlord has a duty of habitability to keep it free from the elements, heat, if it's in a hot climate, maybe air conditioning, running water, electricity. Those are all, free from pests. Those are all habitability issues. Can you make the tenant do everything and anything and just charge them less? It would have to be a separate addendum where it specifically says, I am giving you $200 off your normal rent in exchange for your doing the following things. But you got to check with your state and make sure that is legal. An attorney fee clause. We like to get attorney's fees when we sue for eviction. However, if in your area, your jurisdiction, there's a big presence of legal aid lawyers, free lawyers that tenants get, I would take out the attorney fee clause because it's reciprocal. If you say that the landlord's entitled to attorney's fees if they win in court, then there's a reciprocal right for the tenant to get it if they win. And if you go into court and you win and you get attorney's fees, the chances of you collecting it are somewhere between 1 in a million, right? But if they get a free lawyer from legal aid and they win, guess what? They get attorney's fees from you and you're going to have to pay it. So if you're dealing in low-end rentals in an area where there's a lot of legal aid lawyers available for the tenants and you don't think you're going to collect it anyway, then just take the darn clause out. Limiting occupancy to persons instead of adult persons. This can be a discrimination issue. So again, 3-bedroom place, you can't say if the place is limited to, if they've got an adult with 3 kids, it's limited to 5. You could say limited to 2 adults, but you can't say limited to 5 people because if they have more kids, then that adds, you can't charge them extra for extra kids. That would be discriminatory. And finally, legal pitfall number 8, criminal activity. Criminal activity. So failure to regulate criminal activity that goes on in your property that results in someone being injured can result in liability for you. If you know there's drug dealing going on, and the drug dealer comes to collect his money from one of your tenants who hasn't paid, and there's a big argument, and another tenant opens the door and says, shut the heck up, we're trying to sleep, and the drug dealer turns around and shoots that other tenant, you could be held liable for that by allowing the criminal activity that caused it in the first place. Failure to deal with the activity of other tenants. We talked about this earlier. If a tenant is dealing drugs out of his place or is cooking meth that might injure other people in the building, that can be on you. Criminal activity of your employees or your contractors. Now, generally, you're not liable for that. Generally, you're not. unless you didn't screen them before you hired them, or like the one bite rule. Once there's a complaint, or once there's an arrest, or once there's a conviction, now you got a duty to get rid of this person. Okay? Some other compliance areas, this applies to real estate investors in general. I'm just going to throw like some kitchen sink at you. Federal Trade Commission. The Federal Trade Commission is regulating foreclosure mailings, deceptive trade practices. Attorneys general are always looking out for real estate investors and trying to make a case of deceptive trade practices. Lending regulations. Do you sell properties with owner carry terms? Got to deal with things like Dodd-Frank. Securities regulations. If you have silent partners or you solicit private money. State foreclosure acts, if you're buying from someone who's not just in foreclosure but behind in payments. Corporate record keeping, if you get audited by the IRS or sued and you don't have good corporate records, you could be in trouble. Independent contractors, we talked about that one. Are you calling part-time workers contractors? And there's just more and more and more and more of these. So I'm offering a service. It's a brand new service that I launched called a compliance audit. A compliance audit. Smart companies, especially financial companies, they audit themselves. They have companies that will audit you and make sure that you're in compliance before the government audits you or you get sued or et cetera, et cetera, et cetera. So if you're properly set up to withstand investigations, lawsuits, IRS audits, or local administrative audits, you could sleep a lot better at night. So there's a link right there at the bottom. You can go to legalwiz.com/compliance-audit. Just copy down that link and you can go there and sign up for it. It's a one-time fee, a flat fee of $400. I mean, how cheap is that? And I'll go through your business. We'll have a phone call. I'll go through all your business practices and write up a report of recommendations of where you can improve and what things you need to be concerned about. It's like the Meineke Muffler man says, you can pay me now or you can pay me later. Costs a lot more later. So do yourself a favor. If you're in the business or if you're brand new and you're not sure what you're doing, or if you're dealing with lots of tenants and any of those issues I brought up, a compliance audit would be a really good idea. Okay. Let's open it up to some questions. Let's see here. There we go. By the way, if you're watching on YouTube, make sure you subscribe to my channel, youtube.com/Bronchick, my last name. You could subscribe where you get notifications. I do weekly videos of the week, usually short ones of 5 to 15 minutes, just tips on same stuff, real estate business, as well as you get notifications of the weekly webinars, and you can watch the replays of these weekly webinar Wednesdays. Okay. All right, so open it up to questions now. So let's see what we got here. Okay. Johnny has a question. The question is, what happens if you have someone who is on the what is it called again? He's calling it something else, but it's called the sex offender list. Yeah, the registered sex offender list. Can you bounce them? And I would argue you most certainly can. But beware, if that person also belongs to a protected class, they're going to say you did it because of another reason. Okay, so make sure when you deal with tenants as a landlord, you should have a compliance policies that you go by. So when you take a tenant, it's not just I have a good feeling, it's here's the factors we consider, and have this in writing like a internal policy. We look at credit, we look at credit history, we look at rental history, we talk to previous landlords. How was their attitude when we met them? Did they fill out the application completely? Did they pass the following other tests? And make sure, as long as those things are legal that you're checking for, you have a scoring system. So if you ever got, fair housing claim, you could say, well, this person was bounced not because they were in this protected class, but because they didn't meet this, 10-point checklist, and there's like a demerit for each one. They didn't fill out the application completely, 5 demerits. They had a lousy attitude, or they showed up drunk or stoned for the showing, -5 demerits, and so on and so forth. So some of those are subjective, but if you keep a record of it that looks objective, then you defend yourself against claims. Yeah, German. Yeah, I was just going to bring that one up. What are my thoughts on Oakland, California making criminal background checks illegal on tenants? So the theory is background criminal checks are inherently discriminatory because people of color tend to have more convictions or more dealings with the legal system, or jail time or felony convictions than white people. Now, that might be a correct statistic, but we also, as landlords, want to know if someone has a criminal background. And I don't think that's discriminatory to say, I want to check your criminal background to see if you have a felony. And the city of Oakland says, well, that's not fair because if you're, black, brown, or whatever, you're more likely to have a felony because the system is inherently racist. Whether or not, as a landlord, we want to protect, especially in a multi-unit, you want to be able to protect the other tenants of the building. So if someone has a conviction for, multiple times for assault, you don't want that person as a tenant, and you're doing a disservice to your other tenants by allowing a tenant that has a violent history. Would you want someone who was arrested and convicted of check fraud? Well, not unless they're paying cash, but you don't want someone or someone who was convicted multiple times of drug dealing. That you don't want that type of person. Now, I believe in second chances, and I believe in people paying their dues and getting a fresh start. And I've done that. I've let in murderers, literally people who went to jail for murder. Because it was 30 years ago, it was manslaughter, it was a bar fight, and they were a young, stupid kid. And you know what? It turned out to be a really, really nice guy. But if he was a serial killer, I don't know if I would let him in. So my thought is that's a terrible trend. Similarly, German, the state of Colorado just passed one that says we can't. Well, not that we can't, that the courts are blocked from reporting eviction filings to the credit bureaus unless a judgment of possession was entered. Now, I understand the logic of an eviction filed is just a complaint. It's just an allegation. If it hasn't gone to judgment of possession, it shouldn't be reported because it's like a stigma. I get that argument. But on the other hand, most cases in which a landlord files an eviction for non-payment, one of two things happens most of the time. One, they vacate immediately, and the landlord just drops the case because they don't want to pay for the sheriff, right? They don't need to. The person vacated. Is that relevant information a future landlord would want to know? Yes. Or B, the tenant pays up everything that's owed plus the court costs and attorney's fees, and life goes on. But there was no judgment of possession. But if there were 3 evictions filed within the last 2 years against this person, would I want to know that? Now, if it was a wrongful eviction, the tenant can always explain that before you pull their credit. So a good application should say, and I hope yours does, have you ever had an eviction filed against you? So the tenant could say, yeah, but it was wrongful, and here's the court papers that show I won. And that deals with the issue, especially if it was only one eviction. But if someone had 6 or 7 evictions over 5 years, you got to assume that you're just a chronic non-payer, and you don't want that person. So good question, German. All right. Any other questions about landlord liability issues or this new service, the compliance audit that I'm offering? Great service, by the way. I've been thinking about doing this for years, and I've been talking to so many people about this stuff that, you just don't know what you don't know sometimes when it comes to business. And it's better to find out from me than it is to find out from a judge, from the government, from the IRS, from your ex-spouse, your ex-business partner, et cetera, et cetera, et cetera, et cetera. So go to legalwiz.com/compliance-audit, and you can sign up for that service. Okay. So, that's about it for questions today. We had a lot of people show up, but only a few questions. So thank you for joining, and we'll see you next week on Webinar Wednesdays. Bill Bronchick signing off.